number 38 of the Standing Committee on Foreign Affairs and International Development. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23, 2022. Members are attending in person in the room as well as remotely using the Zoom application. I'd like to make a few comments for the benefit of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom is at the bottom of your screen, and you have a choice of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. Yes. Thank you, Mr. Friedman. Reminder that all comments should be made through the chair. And in accordance with our routine motion, I am informing the committee that all witnesses have completed the required connection tests in advance of the meeting. Now, pursuant to the order of reference of Wednesday, June 1st, 2022, the committee resumes consideration of Bill S-211, an act to enact the Fighting Against Forced Labor and Child Labor in Supply Chains Act.
Point of order. Mr. Chair, can I just interrupt for 1 second?
Yes, Ms. McPherson.
Thank you. I just would like a little bit of clarity from you if I could, because this meeting was not what I understood that the committee was doing, and we didn't get the notice of meeting until Sunday night. And we've never received the list of witnesses, which witness was brought forward from which party. And I just wonder, it makes it very difficult for us to do our work when we don't have that information. I'm wondering if you could provide some clarity on why that was the case and if there are ways that we can avoid that in the future.
Yes. The reason why the notice did not go out is because, first of all, I think the calendar had been sent out to the members previously, so everyone was aware that was occurring. However, insofar as the notice was concerned, the clerk was good enough to send it to me on Friday by email, but I had not seen it until Sunday night. So I am entirely responsible for the delay in sending out the notice. As for the witnesses, I had no say as to which witnesses were selected.
Receiving the list is what I'm concerned. I would like. Usually, we receive the list
for
of
sure.
witnesses.
So, if I could ask the clerk to kindly
Thank you,
clarify.
Mr. Chair. Indeed, I have not distributed the compiled list because I have not received the suggested witness list by all parties. So I'm missing still witnesses from one party.
But we could get the list. Could we get the list of the parties who have submitted witnesses?
I
then?
can, for sure.
Thank you.
Thank you so much. Yes, Mr. Jonas.
Thank you, Mr. Chair. I wanted to raise something just about the committee agenda as well. So we had adopted a calendar on October the 26th, and the clerk had subsequently sent out a proposed revised draft calendar, but the revised version was not adopted by the committee. In terms of what the committee has adopted, it was the original version adopted on October 26th that the committee had agreed to. That agreed upon version had a discussion of the situation in Ukraine scheduled for this coming Wednesday for the full 2 hours. A notice of meeting was published for Wednesday that does not align with the agreed upon calendar. So we're certainly open to a discussion about potential changes to the calendar. In particular, we have an urgent motion on the situation in Iran that we plan to give notice of today. But in the absence of agreed upon changes to the agreed upon calendar, I think it is important that we schedule meetings in accordance with the agreed upon calendar, not with things that were not agreed on. So I think my suggestion would be either we stick to the agreed upon calendar, which is the 2 hours on the situation in Ukraine, or we try to set aside some time today for a discussion of committee business. Again, we're open to that discussion, but in the absence of an agreement, the agreement was that this coming Wednesday we have 2 hours of discussion of the situation in Ukraine.
So as you're well aware, and as was explained to you, Mr. Jennis, the clerk did change last Monday, and that was out of concern to make sure that the committee's time is being used efficiently, because as you know, there were many, many issues that the members would like to consider. So yes, that did change, and S223 is now scheduled for Wednesday. So yes, Mr.
Yeah, Mr. Chair, I understand all that. My point would just be that, with great respect for the clerk, that the scheduling decisions are made by the committee, and the committee has agreed in the agreed upon version that we do consideration
Point of order, Mr. Chair.
the draft interim report. Sorry, I am speaking to a point of order. My point of order was that we had received a notice for Wednesday's meeting that is not consistent with the unanimously agreed upon calendar of the committee. So there may be good reasons that inform someone's opinion that we should adjust the calendar, but I think it is incumbent on the chair to schedule meetings in accordance with the agreement of the committee, unless that agreement changes.
Fair enough. I think. What the clerk is pointing out is that the chair does have the power to move it around to make sure that we proceed in the most expeditious fashion, and to make sure that all those issues that are being considered are considered. That said, yes, if we could go to Ms. Bendayan.
I simply wanted to see, Mr. Chair, if we could get to our witnesses who are waiting, and I felt that this discussion, I would like to respond to my colleague, and we can discuss the schedule, but given that witnesses are waiting, perhaps there is a better time for this.
For sure. Apologies to the witnesses. So can we just proceed with the witnesses?
Yeah, let's proceed according to the agreed upon calendar for the rest of the month, and let's hear from the witnesses. But
no,
we can hash that out on Wednesday if we want.
Efficient.
But I think it's if we're going to have a problem on Wednesday if we are not proceeding in accordance with the agreed upon calendar. That's my only point.
How is that a problem, Mr. Janice?
Because we have an agreed upon calendar. I mean, we're supposed
Well,
to.
yes, but also a chair can make sure that we move along a pace to make sure that all those issues that are of concern to the members are actually dealt with.
Okay,
We can
discuss this on Wednesday, but I don't think the chair can just change the calendar if it's been unanimously agreed on. But I'll leave my comments there. I won't have anything to add. I made my point. Thank you.
Thank you, Mr. Jensen. Ms. McPherson?
Mr. Bergeron.
Monsieur le Président.
Mr. Bergeron?
Mr. Chair, yes. Chair, I definitely don't want to question the opinion that was provided to you by the clerk. That is, that that you are able to adjust the calendar to ensure that the work done is done as effectively as possibly. But perhaps to prevent this type of problem, it would be useful for you to refer to the two co-chairs and the steering committee. That way you would have increased legitimacy in your decision if you decide to proceed to work with the subcommittee to amend the schedule. I understand very well that you want to make the work more efficient, that changes sometimes may be made to the calendar, but you can see that you're putting yourself in a difficult position, the committee as well. I'd suggest then, Chair, that to avoid this type of situation in the future, you call upon the subcommittee for the agenda and procedure, which would prevent this type of situation in the future. Thank you, Chair.
Thank you, Mr. Bergeron. Okay, we'll certainly consider that, Mr. Bergeron. So now if we could go back to our study, which is...
Point of
Yes, Mr. Zuberi.
Thank you. I'd just like to say I respect the fact that you, as chair, have the prerogative to make swift decisions that reflect the overall will of the committee. And I would ask that all members also respect that fact, that that is your prerogative to do exactly what you are doing. And the decisions that you have taken thus far are right and appropriate. I hope we can actually get into what we need to study right now. Thank you, Mr. Chair.
Thank you, Mr. Zuberi. And also, I think the terminology Mr. Bergeron said, he said to add to that legitimacy of the process. So I wasn't bringing up anything new. This was something that all members of the committee had agreed to consider, and I just simply moved around an hour. So, but going forward, perhaps that would be a better approach. Thank you, Mr. Zuberi. So now if we could go back to the study at hand, allow me also to say that concerning the drafting of amendments, I'd like to remind all the members to contact Alexandra Shora, the Legislative Counsel, should there be any amendments of the draft. All that having been said, it is now my pleasure to welcome our witnesses today. We have Mr. Martin Dumas, who's a lawyer and a professor of industrial relations at the University of Laval. We also have from the Mekong Club, Mr. Matt Friedman, who acts and serves as Chief Executive Officer. From the National Council of Canadian Muslims, we have Mr. Stephen Brown, who serves as Chief Executive Officer, and Ms. Fatima Abdullah, who is the Advocacy Officer. And finally, from the Shareholder Association for Research and Education, we're happy to have Mr. Kevin Thomas, who serves as Chief Executive Officer. Each of our four witnesses will be provided 5 minutes for their opening remarks, after which we will open the floor to questions by the members. So, Mr. Dumas, you have 5 minutes, and once you're down to 30 seconds before you hit that target, I will put this up to guide you so you have a sense that you should be wrapping it up soon. Thank you, Mr. Dumas. Please do proceed.
Merci.
Thank you, Chair. Can you hear me well? I'd like to say that if you have any questions, I'd be delighted to respond to them after. I understand English well enough if the questions are in English. I'm speaking not only as a lawyer and a professor, but as a researcher today. I did a doctoral studies at the London School of Economics on the world of work, and specifically child labor in countries that are not as developed as Canada, particularly Uttar Pradesh in India and in parts of Africa. I'd like to first of all quickly summarize my 3 comments on Bill S-211. The first concerns the preamble. If I'm speaking too quickly, please let me know. In the preamble, in the very first whereas, it says that forced labor and child labor are forms of modern slavery. I agree that forced labor is indeed modern slavery, a form of modern slavery, but I wouldn't say that all forms of child labor are forms of modern slavery. I think there's a problem here in the definition of modern slavery. There are countless forms of child labor that are not slavery, and I think etymologically speaking, this needs to be corrected. My second comment concerns the definition of child labor to be prescribed, and that is found in the definition section of the bill. I'd like to specify here that 2 of the paragraphs in this definition, proposed definition, I'll read them to you, or they're on the screen before you, they should be, seem to be more or less appropriate for an initiative that's trying to reduce child labor realistically. These two paragraphs are A and C. A concerns the services to provided in Canada in circumstances that are contrary to the laws applicable in Canada, whereas C concerns work that interferes with their schooling, the children's schooling. That is, labor or services provided or offered by persons under the age of 18 years and that interfere with their schooling by depriving them of the opportunity to attend school, obliging them to leave school prematurely, or requiring them to attempt to combine school attendance with excessively long and heavy work. These are the two paragraphs that, in my opinion, are problematic. I'll tell you why quickly. Based on the study that I carried out in developing countries, or in regions under development, rather, the forms of work that some children did were considered acceptable by their parents, who were really facing very dire situations, dramatic situations. And these are situations that you don't necessarily think of when you're taking a critical look at child labor in the world. I'll give you one example, a typical one. When you strictly prohibit child labor, when the labor does not affect the child's health or safety, but may postpone schooling or even suspend schooling, then there may be situations where the child labor is legitimized. And when this strict prohibition of child labor is implemented, the child may find itself, with their parents' authorization, in a situation of doing an even dangerous job. That's what we've seen in the field. For example, children were not allowed to weave carpets. They were prohibited from it because it was child labor. And weeks later, they were manufacturing bricks under conditions that were even more dangerous. Young women were prohibited from weaving saris, and later, when we returned, they were working as prostitutes in the streets. A very simple example. Another very simple example, there may be a mother who is a widow and may require her 13-year-old son to work to feed the family. I'll leave the rest of my time to answer your questions, but that's basically what I wanted to say today.
Thank you very much, Mr. Dumas. You will have more time during the question period to conclude any remarks you may have had. So now we go to Mr. Friedman. Mr. Friedman, the floor is yours. You have 5 minutes for your opening remarks.
Thank you very much for this opportunity. My name is Matt Friedman. I've been working on the issue of addressing modern slavery for over 35 years in over 40 countries. I now run an organization that works with the private sector in a positive, supportive, non-naming and shaming way. I can't emphasize the urgency of the fact that we really need to do more to address the issue of modern slavery. According to Slavery Index in ILO, the new number is 50 million people from 40 million people as a result of COVID and many other things that are going on around the world. That translates to about 25,200 people entering per day, with a $150 billion industry, and with all of the collective work of all the organizations only resulting in 100,000 people being rescued each year, which is about 0.2%, we really have to do much more in order to address this issue. As we've seen with the statistics, 75% of what we're dealing with is forced labor, and of that, 60% of that is associated with supply chains, which basically brings the private sector into this fight. And so as a result of that, it's very appropriate that we are moving in the direction of talking about legislation that basically brings private sector into addressing modern slavery. When it comes to transparency legislation, it's been around since around 2012. The first legislation was the California Transparency and Supply Chain Act. It basically just said if you're a big company, you have to put on your website what you're doing to address modern slavery. That's all it said. UK Modern Slavery Act came and added more bells and whistles associated with, basically said you have to have an annual report that you submit that addresses a number of things, and then as a result of that, you will have to have that signed by the board of directors. So with each incarnation of this transparency legislation, you see more and more things that are being added. This is important because it helps to sensitize both the private sector to what it is that they need to know, not only in Canada, but in their supply chains around the world. But it also allows for consumers to get a general sense of what companies are doing or not doing. And this is a very relevant and important part of what needs to be done in order to offer the transparency that this legislation is proposing. Why is this bill needed? Well, it will help to educate and inform the companies as well as the government. What's interesting about this legislation, it includes procurement for government agencies as well, which is a kind of a twist or a spin that we haven't really seen in a lot of the other legislation. So this will increase the basic understanding. And I know that this is needed and essential because I recently did a presentation tour across Canada for the last 3 weeks. I was going to Vancouver, Toronto, and Ottawa, and what I was hearing from a lot of companies is they didn't really know much about this issue. They recognized the importance, but they didn't really have the basic information. This bill will allow for that to happen. Will allow companies to submit their basic submissions, and if they don't, fines and penalties will be in place. A lot of the other transparency legislation kind of imply that that happens, but they don't actually have that in place. This is really encouraging because what it will do is ensure that companies take this seriously. We'll encourage other countries to add the public sector element to this, because with each incarnation of transparency legislation, the other countries go back and try to revise and add things in order to, so it's consistent with the global norm. This will create peer pressure because the companies that are submitting will be able to look at the kind of inventory that's online, the public inventory, to compare themselves to other organizations. That's an amazing increase. And lastly, the kind of emphasis on forced labor and child labor clause that focuses on customs and border protection. That is essential. I think that a lot more clarity is needed in order to identify exactly what that means, but in reality, that's a plus. My advice is that if this legislation gets enacted, that it actually gets operationalized. We've seen in other countries that they have it on paper, things are done, but there are a lot of organizations that just don't necessarily comply with what is required of them. I think it's important to get feedback from the private sector. The private sector has a lot to offer when it comes to helping to understand the complexity and the range of supply chains around the world. So the people who are actually overseeing this, who are actually be managing the process, really need some training to understand what's needed. And I say this because I met with Customs and Border Protection organizations that have similar types of oversight, and many of them just really don't have the kind of experience that's needed in order to really address this. I think it's important that we not reinvent the wheel. You know, a lot of these companies really don't know where to start. They are willing to be in compliance, but we have tools that are available. We have organizations that know how to address this issue. We have basically consultation series and procedures. Add something in there that ensures that there are resources to ensure that the private sector can get up to speed. We saw this with the UK Modern Slavery Act. Initially, there was some grumbling from the private sector. Once it crossed over the line, they were like, okay, what do we need to do? So when it comes to that, what do you need to do? There are organizations such as mine and others that are able to help. And within a fairly short period of time, a lot of these organizations could be brought up to steam. With that, I'm done. Thank you very much.
Thank you very much, Mr. Friedman. We now go to Mr. Brown. You have the floor for 5 minutes.
Merci beaucoup, Monsieur le Président.
Thank you very much.
And members of the committee for providing us the opportunity to offer you our thoughts on the study of this committee on Bill S-211. My name is Stephen Brown. I'm the CEO of the National Council of Canadian Muslims. I'm joined today by Fatima Abdullah, the Advocacy Officer for the Council. There are two key submissions I want to provide to this committee. Firstly, and most importantly, is the issue of urgency. We must move swiftly, as there should be not another day in which Canada tolerates the products of forced labor on our grocery shelves. Secondly, and critically, is on amending the language of S211 to clearly indicate that all products arising from East Turkestan, also known as Xinjiang, should not be allowed to come into Canada, subject to a reverse onus provision where companies operating in the area need to demonstrate that those products do not arise as a product of forced labor. Such an amendment is not novel and would bring us into alignment with the current legislative schema, like the United States. We want to be clear. This is a strong bill by bolstering transparency obligations pertaining to forced labor risk. We are here to ask you to pass this bill urgently, but with one key amendment. For three key reasons that I will lay out below, we submit that there are reasons that compel this House inexorably to amend the legislation to ensure that Canada does not tolerate forced labor products from East Turkestan specifically. That is because I'm here on behalf of those who until recently were forgotten. In 2006, our organization called for the Government of Canada to secure the release of Hussein Jalil, a Canadian Uyghur activist who has been detained in China and rendered to the concentration camps. We still do not have definitive evidence as to whether he is alive or not. His wife, Camilla, continues to fight and pray for his return. So let's start with reason number one. This House passed a motion that, while non-binding, labeled what is happening in China right now as a genocide. There's simply no reason to have any equivocation as to whether the CBSA has to use discretion in ascertaining whether products arising from East Turkestan violate S211. Rather, based purely on this ground, it offends common sense and, more importantly, our collective humanity to allow products to be coming to Canada from East Turkestan specifically. Therefore, we have a duty to ensure that the ambit of this legislation captures what is happening in East Turkestan clearly as a prima facie case of forced labor. Secondarily, this brings us into the issue of enforcement. Presently, despite Memorandum D916, the CBSA has been unable to deal with forced labor products arising from East Turkestan. To quote CBSA Director John Osowski, unlike most other inadmissible products, there is no visible cue for a customs officer to understand the labor standards by which a particular import was produced. Establishing the goods were produced by forced labor and compiling evidence requires a significant amount of research and analysis in coordination with other government department partners. The CBSA should not have this level of difficulty in turning back shipments from East Turkestan, and the current context of S211 will not fix the issue. Thirdly, amending S211 allows Canada to come in line with other jurisdictions when it comes to removing forced labor from supply chains. The United States is a good example in this case, since it has already taken a similar measure by passing the Uyghur Forced Labor Prevention Act, ensuring that all goods, wares, articles, and merchandise mined, produced, manufactured wholly or in part in the Uyghur region are denied entry to U.S. ports. We know you and your colleagues may wonder whether this critical amendment is out of scope, or whether it opens a can of worms by raising the question of other specific countries that should be listed. We think both of these concerns are overstated for reasons I'm happy to expand upon. We are urging this committee, we're begging you as parliamentarians to ensure that we take this opportunity of legislation that has strong bipartisan support and make sure we give it enough teeth to make sure that Uyghur human hair doesn't end up in Canadian pillows. That's all we're asking today. I'd like to thank you, and also I note in closing that we expand significantly on the submissions before you in today in our brief that will be submitted next week. So thank you very much.
Thank you very much, Mr. Brown. We now go to our last witness for this first panel, and that is Mr. Kevin Thomas. Mr. Thomas, you have 5 minutes for your opening remarks.
Thank you, Mr. Chair, and thank you for inviting me to present today. I'm the CEO of the Shareholder Association for Research and Education, which is also known as SHARE. And we regularly coordinate investor advocacy on environmental, social, and governance issues alongside most of the major pension and asset management institutions in our country, and also with international coalitions of investors with trillions of dollars in assets under management. We represent a group of direct institutional investor clients of Share, on whose behalf we engage in regular dialogue with boards and management at over 120 Canadian and international
I'm so
companies
sorry,
in which
Mr. Thomas, if we could just pause for a second. I think interpretation is not working, or your mic isn't working.
He'll have to call in because the mic is not connected and he has the same problem earlier.
Okay. Mr. Thomas, I'm being advised that your mic is not connected. We were wondering if it'd be possible for you to call in as an alternative way of making sure that we can hear you.
I'd be happy to try that.
What is the... Oh, my apologies, Mr. Thomas, my bad. So they will call you to instruct you as to how you can make sure that you are properly connected.
Okay.
He can unplug. He can try to unplug.
If you could just try unplugging and plugging in again,
I
perhaps.
just tried that. Now, is it any better, or is this? We had this earlier.
And selecting on the left-hand side. I did that, all of that before.
And if you could also select on the left-hand side,
The microphone.
the microphone on your screen,
Yes,
that is selected, and it's...
it is.
He's the last one, so we'll have to call the question.
Sorry.
Once again, is that any clearer?
It appears that we're having a technical problem. The interpreters can't hear you.
Okay.
No, they can't.
They can't. So if I could ask that we go straight into questions in the interim, Mr. Thomas, you will have someone calling you to ensure that you can connect with us and respond to some of the questions. Thank you. Now we're going to open it up to questions. We will first go to Mr. Jennis, and for the first round, every member is being provided 4 minutes for their question. Mr. Jennis.
Okay, thank you, Mr. Chair. As I had signaled at the beginning, I do want to just use the first minute of my time to provide a notice of motion regarding really an urgent and deeply concerning situation related to Iran. This notice of motion is as follows: that given recent reports of threats to the lives of individuals in Canada from the Iranian regime, the ongoing freedom movement in Iran, and the killing of dozens of Canadians by the regime, including the shooting down of Flight PS-752, pursuant to Standing Order 1082, the committee undertake a study of the threat to Canadians from the Iranian regime and how the Government of Canada should respond. Further, that the committee invite the Minister of Foreign Affairs, the Minister of Public Safety, the Commissioner of the RCMP, and the Director of CSIS to testify as part of this study, and that the committee seek to hear from these officials prior to December 16th, 2022. So that is the notice of motion, Mr. Chair, and I think given what all members would understand to be the urgency and sensitivity of the situation, given that the calendar seems to be more fluid than we thought it was anyways, I think this would be a motion that would be worthwhile discussing as soon as possible, and we would propose that be considered for discussion on Wednesday. But now I'll turn back to the witnesses, and thank you so much for being here. I wanted to start by asking our friends from the NCCM. There are different models that are proposed for, I guess, what some would call a regionalized approach to responding to forced and child labor, recognizing that there are specific situations where, especially in the case of East Turkestan, where forced labor is not something that just happens in the shadows. It's actually being organized and coordinated centrally by the state as part of a genocide, which is very different from some of the other kinds of forced labor that we see in other parts of the world. You mentioned the Uyghur Forced Labor Prevention Act in the United States, other cases of targeted legislative instruments. And I very much agree with you that that Parliament needs to act on this We have Bill S-204 from Senator Housakos that would be a ban on goods coming out of East Turkestan. We could do what the Uyghur Forced Labor Prevention Act does and provide kind of a reverse onus where no goods come out unless there's proof that there's not forced or child labor involved. Could you just speak to why you think it's important to have a regionalized approach as part of our response to forced and child labor? Why it's not good enough to just have the same piece of legislation apply to the whole world, but why we need to specifically be either in legislation or regulation naming regions and responding to the particularities of those situations.
Right. Well, thank you very much, Mr. Jenis. I'd also like to thank everybody who's here and for their work on getting this bill to where it is. I'd also like to thank the senators who sponsored the bill. On your question specifically, yes, I agree. Actually, the reason why we believe it's so important, specifically in this case, to mention East Turkestan, we think there's three key reasons that compel specifically. One, I think we have to remember that the House passed, while non-binding, a motion labeling what's happening right now in East Turkestan a genocide. So there's no reason to equivocate as to what's happening over there. Everybody knows exactly what's happening. Second of all, this brings us to the issue of enforcement. So given the fact that there's no legislative framework that actually relieves the CBSA has actually no visual cues to be able to determine what is coming out of East Turkestan, right? It's very difficult to ascertain what is actually coming or how to actually source those goods. So having legislation that relieves them of having to do a very onerous process of trying to determine where those products come from, where they were manufactured, and having reverse onus provision that actually places responsibility on companies operating in the region actually allows the CBSA to do their job. And then the last thing, I think it comes in line with other of our partners. So the United States, the UK, and as well as Australia have all passed legislation recently. So I think there's many examples of how to do this. There's many reasons why we should do this. The fact that there's a genocide happening over there, it's clear. And I think we need to be able to give law enforcement the tools that they need to be able to do their job. Yeah. Thank you.
That is for 4 minutes, Mr. Chair. So.
Yes, that's correct. So we now go to Mr. Zuberi. You have 4 minutes, Mr. Zuberi.
Thank you, Mr. Chair. And I'd like to start off with Mr. Friedman. If you can just map out for us, please, this piece of legislation, S211 right now, and how it's situated within the framework of similar legislations in other jurisdictions. If you can just map that out for us. In particular, you talked about the evolution of transparency type legislation and how this also lands within that evolution over the years.
Yeah, basically what you have with this legislation is many of the same components that you would find in Australia, UK, and the California Act. But as I mentioned, there is a progression over time. California was simple, UK was a little bit more, Australia was a little bit more. What you have added that's different is the procurement emphasis of the public sector, which is extremely relevant and important, and more of a kind of a benchmarking of the fact that if a company does not comply, there will be fines and penalties associated with this. As I indicated, in the other acts, they imply that some type of punishment will occur if compliance doesn't take place, but it's really not spelled out, and we really haven't seen that applied in the other transparency legislation components. And as a result of that, there are a lot of companies that just simply don't submit anything at all. And so I think what makes this different is that you have criteria that's a little bit different in terms of the revenue and the assets and the number of employees related to companies and so forth. But this emphasis on really ensuring that companies submit, it goes into a public registry, is what makes this further along in the kind of transformation of transparency legislation. And I think what will happen over time, as I said, is that other countries will catch up to where you guys are. So you're setting the bar up higher than what we've seen in other legislative presentations.
how important, very quickly, Mr. Friedman, how important is it to get the buy-in from the corporate sector within Canada for a piece of legislation like this, or dealing with due diligence? How important is that?
Many of the companies are already doing this for other transparency legislation. If you have products in the UK, you're already submitting. So I feel like the corporate sector, I think their inputs are essential in helping to clarify the direction of this, but the writing is on the wall. This needs to happen. And it's going to happen in many other countries as well. Let's go ahead and get this legislation across the line. And I really don't think it's going to be a burden or a problem. What it does is sensitizes the corporate sector to what they need to do. It educates them, informs them. The peer pressure will get them to actually be involved in.
Friedman, thank you for that. And what you said about getting this legislation through the door and passed is echoing what others have said, other witnesses, including from National Council of Canadian Muslims. I'm going to give the remaining time to my colleague, Ms. Bendayan.
Merci beaucoup.
Thank you very much, dear colleagues. Mr. Dumas, I was really affected by what you said in your opening comments. Please explain to us, either here or in later, by following up in writing, the specific amendments that you're proposing to Section 2, the definition of child labor, that is. If I understand correctly, you want to strengthen the definition. That interests me a great deal. Could you please elaborate and perhaps...
So if we could just get a very brief response, less than 20 seconds, please.
Thank you. I'm not really sure that we want to strengthen, but I strengthen the definition, but I change it by eliminating the two paragraphs I mentioned. That is, paragraphs A and C in the definition of child labor. So it makes this definition looser. Is that right? Yes, that is. The definition would be restricted to the worst forms of child labor. That would be much more efficient, in my opinion. In the field, there may be a great standard on paper, but in the field, it's very hard to apply. Why? Because it's hard to trace what work children are doing. If you really want to do it, you need to have the authorization and the trust of the local community.
Mr. Dumas, my
Already?
very much so. Sorry, I asked for a 20-second response, and then there was a follow-up question. So we will now go to Mr. Bergeron.
Mr. Bergeron, you have 4 minutes. If you'll allow, Chair, first of all, I'd like to thank all our witnesses who are here today, whose comments have enlightened us. I'd like to follow up on what Ms. Bendayan said, or at least on what she wanted to say. Mr. Dumas, you spoke to us in your opening comments about 3 comments: the preamble, paragraphs A and C of the child labor definition, and the third comment, I believe. There was a third comment. Would you like to take this opportunity to say what your third comment is? Yes, thank you. One moment, please. Can you hear me? We hear you very well. The third element is that it's very difficult to have an effective control process when it comes to child labor. And this is even more random. It would be even more random if it's based on written reports. If ever you want to compare the facts in the written statements with the actual situation, this should examine specifically the worst forms of child labor so as to avoid unintended consequences of strict prohibition. As I mentioned, the substitution of one prohibited job for another more dangerous one. And the second problem to avoid is the concealment of visible forms of work, that is, through illegal work or clandestine work. If your definition of child labor is too broad, the communities who believe that certain child labor is legitimate will avoid allowing this work to be done openly, and it will become clandestine, hidden work, and the problem will be even greater. It will be much more difficult to detect these forms of child labor. We've seen very perverse effects in the past with too broad a definition, and I wanted to just draw your attention to these effects. By concentrating on the worst forms of child labor, your work would be more effective because you would be improving the situation of a child who's working under very bad conditions. In other cases, or rather in these cases, you would be improving, or rather otherwise, you would be affecting a family where the child's labor really helps a family, in the case of a widow who relies on her son, for example. And this situation requires much more than you may believe. Thank you, Mr. Dumas. I find this very interesting and somewhat disturbing, actually, this information that you've just given us about child labor. Listening to you speak, I thought to myself that even here, when there's a social safety net, some forms of child labor are allowed. For example, working for your family's business, working in farms, in the fields. And increasingly, young people are working in businesses, fast food restaurants, for example, because of the labor shortage, despite this requirement to stay in school until 16. I think it's interesting that we're trying to tell developing countries what to do when, in fact, there is certain forms of child labor here in Quebec and in Canada, and these forms of child labor would not meet the definition or would be considered unacceptable based on this definition in A and C.
But we will provide the witness maybe 25 seconds to respond briefly to the concern identified by Mr. Bergeron.
Oui.
Yes. I can speak for a few more seconds. Yes, you have 25 seconds. All right. What I was going to say was that even if in Canada certain forms of child labor are permitted, we have a situation where we can prevent these children sacrificing their studies to work. And as I was saying earlier, in many countries in the world, children will be allowed not to go to work, to school rather, so that they can make the best of a bad situation. And this may be also to prevent. There's also the question of preventing a worst form of child labor. This is a real problem, as I've mentioned. It's often seen in the fight against child labor that the child switches jobs to a worse job, a more dangerous one. Even if you don't change the bill at all, I think it will be difficult in the field to eliminate these forms of child labor under this definition. You won't have the community's cooperation.
We now go to Ms. McPherson. You have 4 minutes.
Thank you, Mr. Chair. Thank you to all the witnesses for being here today to talk about this very important legislation. It's very interesting to me. My concerns, of course, stem around the difference between asking for reporting and for companies to do the reporting diligence versus action being taken. And so I definitely hear what our friends have been saying from NCCM, that we need to act with the urgency that this requires. I also have concerns about how we are operationalizing this, because this is a concern we have with regards to other things like at the sanctions regime and whatnot. I might just start by asking you, how many shipments have CBSA seized? And compared to other countries, how is Canada doing? And perhaps that can illustrate a bit the urgency with which this legislation needs to be brought forward.
Yes, absolutely, MP McPherson. Thank you very much for your question. The CBSA has actually intercepted one shipment, compared to the United States of America, who has intercepted about 1,300 since they passed similar legislation. So we have a lot of catching up to do.
Thank you. Well, and one of the things that I'm interested in is how we can make this legislation stronger and make sure that it is, in fact, not just giving businesses or companies an opportunity to report on their forced labor within their supply chains, but actually be responsible for ensuring that it is not there. So what countries have been doing that best? Which countries do you think have been models for us that we have heard that other countries have moved faster? Is it the French? Is it the Germans? Who has moved furthest? Because that's where I would like us to go.
I think different countries have actually taken different models. So some countries, for example, in Europe, have placed very onerous responsibilities on companies, right? But they have a cap at very large companies. I think the legislation in front of us today actually takes an interesting approach in that it actually covers a broad range of companies, including mid-sized companies. However, if we actually look at the results, I think our neighbors to the south, the results speak for themselves. So, 1,300 shipments seized, and they're continuing to do more. So, yeah.
Thank you. And I just wanted to give one last moment. I'm not sure if Mr. Thomas is able to finish his thoughts with us, because I know we were having some struggles with his mic, but if he can,
Yes.
I would like him to have
I can assure you that he is now properly connected, so he should be audible.
Perhaps I could give him just a last little bit.
You're ready to proceed now? Yes?
Yes.
Okay,
Please do.
great. Well, and before I speak to the contents of the current bill, maybe I can provide a brief example to demonstrate the challenge that Ms. McPherson just mentioned of only requiring modern slavery reporting versus requiring an obligation to perform human rights due diligence. Last year, on behalf of its shareholders, we began engaging a Canadian headquartered multinational renewable energy company after it was reliably identified as having supply chain links to forced labor in the Xinjiang region of China. And actually, shipments of its product were even reportedly detained by U.S. customs officials, as we were just talking about, on suspicion of these links. So we had a clear case of a very real material risk to the company and its investors. But despite those credible allegations, the company said there's no forced labor in our supply chain. We don't believe there's forced labor in our industry. And in fact, the company and many of the investors we reached out to said, well, this company's got a modern slavery statement. It's right there on its website. And it says everything's fine. We have zero tolerance for forced labor anywhere in our supply chain. But what this statement didn't include was any detailed information that would help us as investors to know whether our companies taking meaningful and effective action to implement these commitments. There's no indication of how they identify human rights impacts, which stakeholders are consulted, how many instances were investigated and acted on, what corrective actions the company's taken. And in fact, our review, when we looked closer, found the company didn't have any system for investigating or addressing human rights impacts in the Xinjiang region, for good reason, because investigators can't even get into that region to check allegations of human rights abuses. So when we continued to try to push the company on this and to develop a due diligence system, they just said, just trust us. And I tell you that story because it's indicative of the primary challenges we've got as pension plans, as banks and asset management firms here in Canada when we're trying to meet our fiduciary duties to assess risk. We can't properly assess it without this kind of, sorry, Mr. Speaker.
Yes, sorry, we're considerably over the time slot
Well,
that was
Mr. Speaker, I'm
provided.
just wondering if we could let him finish because we did invite him to come and I'm prepared
Fair
to give
enough.
him my time, but
But also, I mean, we're eating into every other member's time as well.
we would have normally given him
but-
the time to speak, though, I think.
Yes, but what we will do,
He's a witness
terribly
we
sorry for this technical difficulty, Mr. Thomas. We have received your statement. We will ensure that it's translated and sent to all the members. But if there's anything additional that you would like to also explain to members of the committee, we would welcome that as well. Thank you.
I appreciate that, Mr. Chair. Thank you.
Thank you, Mr. Thomas. We now go to the second round. Each member has 3 minutes for the second round. Mr. Epp, the floor is yours.
Thank you, Mr. Chair, and thank you to the witnesses. I'm going to begin with a statement just to Mr. Duma. I appreciated your comments clarifying child labor. My own background growing up on a family farm, my parents did not interfere with my education, and the 4 daughters on our own farm were raised with love and an encouragement to work. So I understand those nuances. I have not brought tomatoes to this committee yet, but I will today because that is my background. And so I'd like to go to Mr. Brown, please. The world produces about 37.2 million metric tons of processed tomato products. China did 6.2 million tons this last year, of which 5 million came from Xinjiang province. There are certainly allegations of forced labor from the Uyghur population, particularly into the tomato industry. And so I'm wondering if you have any comments, any specific knowledge regarding exactly that to the extent. I grew up hand picking tomatoes. My kids grew up on a machine. My understanding, most of the production is hand harvested and forced in China. Do you have any comments specifically on the tomato industry?
Right. Thank you very much for your question. So, as many people have, we hear anecdotal evidence of some of the practice of slavery that's happening right now in East Turkestan. But in terms of specific data, I don't have any specific data to provide you right now. But what I can do is I can follow up with your office afterwards.
Thank you. Regarding the attestation or the exemption to import prohibition from companies, how would you work with that if Kafka, which happens to be one of the main tomato purchasers in Xinjiang, is a state-owned enterprise?
That's an excellent question. I think it comes back. I think to the main request that we have for amending the bill. I think anything coming out of East Turkestan, any product that's being produced in East Turkestan, any business having operations in East Turkestan should have a responsibility to prove that what their products do not contain forced labor. I think right now the situation in East Turkestan is such that it only makes sense to assume that everything that's being produced in East Turkestan is a result of forced labor, and therefore it shouldn't be on the shelves of Canadian grocery stores.
Thank you. In my remaining time, I'd like to go to Mr. Thomas, please. Can you talk a little bit more about the thresholds, the impact of threshold for reporting in this legislation, and what are the opportunities to actually get at the intent of this legislation with companies, and I'm thinking of small tomato importers in Canada, who might not meet that threshold?
The thresholds are important because we do want to make sure that a company has the capacity to institute due diligence systems. There's no point in asking your corner store to develop that kind of thing just because it's incorporated under the CBCA. So I think those thresholds are appropriate. We've consulted with a lot of businesses in the retail sector, particularly around the thresholds, and what we found is that they're more or less in the right place. We're not really concerned about that as a problem in the legislation. We are concerned that there's a requirement that there is a due diligence system. That's the part that we haven't seen in the legislation so far. There's a reporting requirement, but the answer could simply be no. And the key here is making sure there's a positive obligation to due diligence.
Thank you. Thank you, Mr. Chair.
Thank you, Mr. Epp. We now go to Mr. Sheehan. You have 3 minutes, Mr. Sheehan.
Thank you very much, Mr. Chair, and thank you to all the witnesses today for their excellent testimony and also their advocacy on this important subject. And thanks for the committee for undertaking this important work. Since I only have 3 minutes, I'm going to ask Martin Dumas the following question. Bill before us sets out a transparency framework for businesses and government institutions, but does not set out a due diligence framework. So it's a two-part question. If Canada were to adopt this transparency-based approach, how would it compare to other international jurisdictions? And in your opinion, is there any way we could include not only a general set of transparency obligations, the covered entities, but also due diligence obligations for a subset of the universe of covered entities under the bill? Thank you, Mr. Chair. To Martin Dumas, is he still online? Martin?
Allô? Oui, bonjour.
Yes, hello. I think, can you hear me? Yes. I don't know if, with regard to transparency, we can do much better than other countries. What I do know is that no matter what the level of transparency reached, let's say we wanted that level to be very high, it will be hard to have assurances that the monitoring has actually been done in the field. As I've said earlier, if we want to ensure that a child or children will not intervene, will not work on certain products, we need to have the local community's confidence and trust so that we can obtain the proof. I've been in the field, that's how it works. Otherwise, it's very difficult to find out about child labor. And to obtain the community's trust, we need to focus specifically on the worst forms of child labor. Otherwise, we won't be able to overcome barriers. For example, in some cases, the place of work may be guarded by armed guards. We need to have a consensus with the local community with regard to unacceptable forms of child labor. If the definition of child labor is too broad, we'll be taking part in a sort of Western paternalism, and that's what I'm getting at. If we're too paternalistic, then the transparency question won't really work. So I'd warn you about that. If we want to improve the effectiveness of the monitoring and transparency processes, we first have to make sure that the forms of child labor that we're targeting are the worst forms. And that's where you can make improvements across the board, both administratively and with regard to monitoring, effective checks. Otherwise, it's just smoke and mirrors, as you say in English.
Same question to Matt Freeman.
I'm afraid you're out of time, Mr.
Oh, okay.
Shea.
Thank you, Mr. Chair.
So we now go to Mr. Bergeron.
Mr. Bergeron, you have 90 seconds. Not 3 minutes? No. In this...
And you get a minute.
I'm not a member. Monsieur Brown.
Mr. Brown, a quick question. You yourself have raised the difficulty that border officers have distinguishing between what's coming from the Xinjiang region and other products. I'm eager to see your brief, to see the details of what you're proposing. But will it not, what you're proposing, not come up against the same hurdles? That is, that we wouldn't be able to specifically identify what comes from Xinjiang, which we currently can't anyway. If it comes from Israel, we won't be able to determine what comes from the occupied territories. How can we get around this hurdle or overcome this hurdle? Answer. Thank you very much, Mr. Bergeron, for your question. I think it's a question of, well, what we'd like to see is that all companies operating in this region be required to demonstrate, to prove that what comes through their supply chains or from their supply chains does not include forced labor goods. I think when you'll see our brief with the details, you'll note that the U.S., for example, has a very good system. There's a whole list of what needs to be demonstrated before these goods can be approved for entry into their country. As soon as you have operations in this geographic region, you must prove, you should have that responsibility to prove that your products are not the result of forced labor. Thank you, Mr. Brown.
We'll go to the last question for Ms. McPherson. You have a minute and a half.
Thank you very much, Mr. Chair. Mr. Thomas, you spoke about how you would strengthen this bill. I'd like to just give you a moment to tell us about any amendments that you would be interested in having brought forward, what that might look like.
Thanks. One of which I think we should speak to is the question of scope. Right now, it's narrowly focused on child and forced labor, and I appreciate what the other witnesses have brought forward on this question. Those are obviously egregious human rights abuses, but as we speak to perhaps what Monsieur Dumas has been speaking about, what happens with children, one of the solutions to addressing child labor is also to make sure that the human rights and workplace rights of the parents are respected. Every company we deal with on human rights due diligence doesn't stop in doing due diligence just for child labor or forced labor. We believe that the scope should be human rights as defined under the UN Declaration of Human Rights, as well as the ILO General Principles for Rights at Work, the fundamental principles for rights at work, because that will capture the whole essence of what's happening in these supply chains. And I submit will actually help us to address the question of whether there are adverse effects for children when their parents are not receiving their rights at work as well. So I would definitely expand it that way, make it a mandatory requirement that there is a due diligence system, and expand the number of reporting requirements to include things like grievance systems, which are, again, well established in OECD guidance on this and in the United Nations guiding principles for human rights and business. So that's where I would go, short and simple.
Thanks very much.
Thank you ever so much, Ms. McPherson. So we will now be moving to the second panel. But before doing so, allow me to thank all of the witnesses who have appeared here, assisted us in better understanding this bill. We're very grateful for your expertise. And allow me to reiterate one more time, Mr. Thomas, our apologies for the technical challenges that you experienced. Thank you.
Thank you.
Witnesses can leave, and we will adjourn for a couple of minutes.
Merci.
Suspend.
Thank you.
Minutes. Yeah. We don't. No one has to. They don't have to. are very, very grateful that three witnesses will be joining us for this hour. We have with us here from the Canadian Network on Corporate Accountability, Ms. Emily Dwyer and Ms. Kalpona Akhter, the director of the Bangladesh Workers Solidarity Centre. We also have from the International Justice Mission Canada, Ms. Cheryl Hotchkiss, who is the Director of Strategy and Operations. She is joining us virtually. And lastly, we have from the Regroupement pour la Responsabilité Sociale de Entreprise, Ms. Alice Chepot, the Executive Director. Each of you will be provided 5 minutes for your opening remarks, and after we have concluded that, we will open it to questions from the members. 30 seconds before your 5 minutes are up, I will put this up, so if you could kindly wrap it up as soon as possible. So that having been said, we will go first to Ms. Emily Dwyer. Ms. Dwyer, you have 5 minutes.
Good afternoon. Thank you very much for the invitation to be here. My name is Emily Dwyer. I'm the Policy Director at the Canadian Network on Corporate Accountability, CNCA. Nous sommes reconnaissants.
We are grateful to Parliament for taking this question seriously, and we urge you to act rapidly so that the countless human rights violations to respond to the human rights violations in supply chains.
Canadian companies are profiting from it, and Canadians from coast to coast to coast want Canada to take decisive action to eradicate forced labor and other human rights abuses from Canadian supply chains. But in its current form, Bill S-211 would not prevent exploitation and abuse. Bill S-211 would do more harm than good. Our network of 40 organizations and unions from across the country was formed in 2005 to collectively call for mandatory measures to require companies to respect human rights and the environment in their global operations. We represent the voices of millions of Canadians, and our members have long-standing relationships with communities, women, Indigenous peoples, and workers around the world. Our membership does not support Bill S-211. This is because the bill, as currently drafted, would allow Canadian companies to continue to profit off of human suffering and environmental damage. The harm we're talking about is not trivial. It ranges from forced labor, land and water contamination, workers' rights violations, killings, gang rapes, many of these linked to Canadian mining, oil, and gas operations abroad. Canada needs the right legislation if we are serious about tackling corporate abuse. Simply put, a law that requires you to report but does not require you to stop the harm you're causing may be easy to pass with all-party support, but it is also meaningless. What is needed is a law that goes beyond a basic reporting requirement. To get widespread support of civil society and to catch up to global momentum, supply chain legislation should, first, focus on preventing and remedying harm rather than reporting. Second, help impacted people access remedy. And third, apply to all human rights. At best, Bill S-211 is meaningless, as it will not improve the situation for those who are harmed. At worst, the bill is damaging because it creates the appearance of action to end modern slavery without actually having any such effect. Bill S-211 does not require companies to stop using or to stop profiting from child or forced labor. It does not require companies to take any steps to identify whether slave labor is in their supply chains. It does not require company directors to certify that their supply chains are free of forced labor. If companies do make use of child or forced labor, the bill doesn't offer help to the victims at all. This means that a company could comply with Bill S-211 by taking no steps or by taking patently inadequate steps, remaining willfully blind, and continuing business as usual. The evidence from other countries confirms that reporting-only laws have not been effective in addressing corporate abuse. For example, A 5-year review of the UK's modern slavery reporting registry, quote, revealed no significant improvements in companies' policies or practice, end quote. And, quote, failed to be an effective driver of corporate action to end forced labor, end quote. Europe is moving away from reporting-only approaches towards mandatory human rights and environmental due diligence laws. Canada should do the same. It is urgent that communities and workers harmed in Canadian supply chains be protected from abuse and have access to remedy in Canada. We hope that the process currently underway will ultimately lead to such a result. But we want to be very clear. Our network's position is that if S211, as currently drafted, were to go to a vote today, we would be advising MPs to vote no. We also believe that this committee needs to hear from directly impacted people and workers, and we note their absence from the speakers list. Kalpona Akhtar, herself previously a child worker and today a world-renowned labor rights activist from Bangladesh, joins me today and can intervene during the question and answer period. We hope that the committee will expand the number of sessions it holds so that it can hear directly from the directly impacted people around the world. Thank you for your time.
Thank you very much, Ms. Dwyer. We now go to Ms. Hotchkiss. Ms. Hotchkiss, you have 5 minutes.
Thank you. Greetings, committee chair, committee members, and fellow witnesses. My name is Cheryl Hotchkiss, and I am from IJM Canada, or IJM. IJM is a global organization seeking to protect people living in poverty from violence. We partner with local authorities in 29 program offices in 17 countries to combat trafficking and slavery, violence against women and children, and police abuse of power. 50 million people are now estimated to be enslaved around the world. Of these 50 million, 28 million of them are caught up in forced labor. The combined impacts of COVID, conflict, and climate change have pushed more people into poverty, making them vulnerable to all forms of exploitation, including forced labor, and have pressed parents and families to remove children from schools to work to help their families survive. In countries where there are high rates of poverty, particularly extreme poverty, you will find broken systems. Systems caused in part by governments unable or unwilling to provide leadership to creating and maintaining healthy justice and social systems. COVID, conflict, and climate change cause further degradation of these systems. Unhealthy systems enable all forms of lawlessness, create instability, and breed fear. People living in poverty are forced into jobs where they can make a meager income in risky jobs that often take them away from families, leaving them further isolated and at risk of exploitation. For women in forced labor, there's an increased risk of violence, particularly sexual violence. IJM is exposed to this grim reality in our efforts to help the most vulnerable receive protection and support from systems that didn't prevent and maybe even enabled exploitation. We know that an unhealthy legal system needs many actors to improve it and make it work for the most vulnerable so that they can find decent work where there's no fear of violence and exploitation. We believe that corporations have a critical role to play in helping unhealthy systems to improve and effectively protect vulnerable people. We appreciate that corporations are focused on generating good returns for investors and creating products consumers want. They are not responsible for playing the role that governments should, but they have influence that can encourage and help governments undertake their responsibilities to protect their citizens effectively. This is why for IJM, Bill S-2211 is important. We know corporations have a positive opportunity to impact justice system reform. The governments in these countries where there are forced labor need corporations to have stable and environments within which to do their work, to gather resources they need for their products. Unhealthy justice systems mean unstable society for everyone, including corporations. Voluntary codes of conduct or individual corporate efforts to address exploitation in supply chains to create an unlevel playing field for corporations importing and selling products in Canada. Those that want to address forced labor and child labor in their supply chains bear the costs associated with that on their own and pass that on to the consumers. Bill S-211 will enable justice and labor protection reform. It will do this by creating the conditions where corporations can work together and will be encouraged to work together to know what is in their supply chains. We've seen this happen with the Seafood Task Force in Thailand and Malaysia, where companies collaborated to create a level playing field to operate in the wake of similar legislation regarding forced labor in the fishing industry. With that information, they can act on their own or as a collective to press governments to take action, concrete action to improve justice systems for the most vulnerable, which includes listening to people who've been caught up in exploited labor and forced labor. The bill will provide a collective and impactful deterrent to ending forced labor and child labor through the imposition of the import prohibition. This ban levels the playing field for corporations who are making efforts to address forced and child labor in their supply chains to compete with those who aren't taking any action. Finally, it will give Canadians who care about the impact of their consumer choices information to help them make better choices and to use market forces to improve supply chains for all products sold in Canada. IJM is encouraged by Bill S-211 and wants the Canadian government to be involved in progressive efforts taken by other G20 nations so that the next ILO report on modern slavery has the numbers going in the right direction, downward. Thank you.
Thank you very much, Ms. Hotchkiss. We now go to Ms. Chapeau. You have 5 minutes as well.
Hello, everyone. I would like to thank the Standing Committee on Foreign Affairs and International Development for giving me the opportunity to speak to you. I'm Alice Chipot, and I am here as General Manager of the Regroupement pour la Responsabilité Sociale des Entreprises. We're based in Montreal. An organization brings together more than 50 committed investors, that is, religious communities, foundations, nonprofits, research centers, and individuals. For more than 20 years, we have been working for business practices and corporate behaviors that live up to Quebecers and Canadians' expectations. We're fighting for social and environmental justice. We've joined the CNCA to push Canada into putting in place a complete due diligence framework. We welcome legislative efforts to eliminate modern slavery and any type of forced labor in international supply chains. However, we believe that the current bill has missed its mark. It has missed its target by trying to split human rights issues from effective legislative mechanisms. In its current form, S-211, which has taken a step-by-step approach, is too weak to have a real impact. It's based on reporting, sanctions, marginal fines that are even symbolic for bad corporate players. At the RRSE, as a group of investments, we have been doing shareholder engagement for the past 20 years. What does that mean? That means we work every day with the concept of reporting and data, and we closely look at supply chain information. We try to assess big corporation practices, their reports. Even if some corporations have shown improvements when it comes to human rights, we can easily say that the reporting process is not sufficient to stop and correct negative impacts on the environment and on people's conditions. Only a review of the Canadian legislative and regulatory framework that prevents bad behavior and imposes sanctions on repeat offenders would provide an effective response. There must be new mechanisms and even reparations in case of abuse. There should be a role given to the courts. That's their only genuine deterrent. There are good practices. We haven't mentioned them in this text, but there are good proposals out of Europe, Germany, France, and the Netherlands in particular. This would allow us to have a good set of documentation. We've just come out of COP27, and we heard what the southern countries have asked for. I join my voice to Jacques Nzumbu, a Jesuit specialist in Canadian mining in the Congo, who came to see you. He explained the reality of his people and his call to protect the kids and the children of his community. I also join my voice to the Uyghur community of Montreal, who's come to see us seeking help and asking that we make modern slavery more, that we expose modern slavery in the Xinjiang with the help of Canada. I join my voice to Capellas, who's come a long way from Bangladesh to talk to us about the conditions that she and her co-workers face. From our point of view, reporting is not enough. We've reached a point where we need a lot more ambition and a lot more effective way to put an end to these corporate practices. Thank you.
Thank you very much. And now for the first question, we go to Mr. Jennis. Mr. Jennis, you will have 4 minutes.
Thank you, Mr. Chair. Thank you very much to all of our witnesses. And I did want to make a comment about consideration of this bill just to the beginning. I know we've had proposals for amendments. There may be other members that are considering amendments. I think it would be very worthwhile for anyone who's considering putting forward amendments to ensure that members of this committee have an opportunity to review them in advance. I think it'd be worthwhile actually for witnesses to be able to see and comment on amendments in advance, because dropping amendments at the last minute that important witnesses haven't had an opportunity to provide feedback on is not really a very effective way to legislate. So I do hope that those that are contemplating those kinds of proposals will share them with the public and with committee members in sufficient time that allows some of the folks that are here and other witnesses to be able to provide feedback, if not verbally, then certainly in writing. That's seems like a best practice when it comes to legislating. I want to, in terms of my questions, start with Ms. Hodgkiss. I wonder if you can just share a little bit more about the work of IJM when it comes to these issues. The committee is looking at some other issues, such as the situation in Haiti and kind of the breakdown of rule of law there, where your work on police reform, on justice might have some relevance as well. So if you could maybe take a minute to share just more broadly for those that are less familiar about what IJM does, I think that'd be very worthwhile.
Thank you. Sure, I'd be happy to do so. I think where IJM focus is on inside the systems, people working within the systems. I can't speak specifically to the situation in Haiti, but I do know in situations like in Myanmar, where there's instability in the government, our training that we've done of police and other officials on the ground has continued to ensure that efforts related to trafficking into forced labor into the Thai fishing industry, for example, continues. And we also know from a prevalence study that we have done in Tamil Nadu related to bonded labor, we know that IJM's work directly impacted the reduction of 77,000 people in bonded labor. But we also know that as a result of our efforts in system building, educating judges, police, and so on, resulted in over 430,000 people being freed from bonded labor. So we believe very strongly in the role and the opportunity of government and government actors to be trained, to understand their roles and responsibilities with their citizens and protecting citizens, and the knockoff effects that has on others who may be potentially victimized by criminals who are operating and forcing people into labor.
Mm-hmm. What do you think Canada's international development assistance can do to strengthen justice systems and promote police reform around the world?
Well, where we have seen some success is the ones I've mentioned to you, partnering with organizations like IJM that are doing judge training. In fact, we have just had an IJM volunteer who's a judge Justice Dallas just returned from Bolivia, who was doing training with judicial officials there. We're looking at continuing that, and we know that the impact that can have is ensuring that cases move through the court system where there's a crime of sexual violence or forced and exploited labor. Those cases can actually be brought before the courts and receive the punishment, and criminals are brought to justice.
Thank you very much. My next question is to Ms. Dwyer. I understand that there are amendments you're seeking in terms of changes to this bill. I mean, it would seem to me that regardless of those other proposals, that that taking what most people recognize as a step in terms of exposing awareness, encouraging companies to be reporting on this, that would be a constructive step, at least in bringing more attention to light in this, and that's generally what we've heard from witnesses. I know your network feels differently. Help us understand, though, why it wouldn't be worthwhile to still take this step. Yeah, love to hear your feedback.
The evidence in other jurisdictions where this kind of modern slavery reporting law has been brought forward is that it hasn't had an impact in changing corporate behavior. It hasn't had an impact in helping to root out or deal with forced labor abuses. But at the same time, so it doesn't help solve the problem. And at the same time, it also has quashed momentum towards more effective laws. So if you look at the situation in the United Kingdom, in Australia, their civil society space to move forward other laws closed. The time for Parliament to speak about those issues closed. So it quashes, by making it look like the government is doing something, that there's a law on the table, that the momentum towards more effective legislation gets pushed back. And I think that there's a parallel that we can put in place with the situation in Canada. It's almost 5 years since the Government of Canada announced the creation of an ombudsperson's office to independently investigate, and we're still now waiting for that to happen.
Yeah. I would just say this isn't a government bill, right? So, okay.
Mr. Janice, we're well over the allotted time. So we now go to Ms. Bendayan. You have 4 minutes, Ms. Bendayan.
Merci, Monsieur le Président.
Thank you, Chair. And I'll be asking I would like to ask a question to the RRSE, but first of all, I'd like to read an opinion, a notice of motion, rather.
Following motion, before I ask my questions, Mr. Chair, that pursuant to the Standing Order 1082, the Chair be instructed to schedule the first meeting of its study on women's sexual and reproductive health and rights no later than Monday, December 5th, 2022. I give notice of the motion. I am not moving the motion at this time, Mr. Chair. Oui, alors...
So, Ms. Chipot from RSE, thank you very much for your opening comments. I really liked the way you expressed your concerns. You've been very clear by saying that reporting is not enough, and I agree. You raised the example of France and Germany, countries that have due diligence mechanisms. Should we be focusing on that? And if so, could you give us an idea of who would be targeted, who or what would be targeted by these requirements for due diligence? Would we be using the same definition as Germany? What would you suggest? A response. When it comes to the definition, I'll perhaps ask Emily and the CNCA to respond to that question. I know they've worked very hard on this question. What is certain is that we need to expand our scope of our understanding of human rights and the consequences of violations. This bill, however, is targeting specifically modern slavery. We need to take a broader approach. And the strength of the bills that are found in Germany and France is that they take the broader look, really focusing on corporations and involving the courts to condemn them. If you want more specifics, Emily can give you the exact definition that should be used. Am I answering to your question? Yes, and I don't have much time, so go ahead.
Est-ce que vous préférez?
Would you prefer that I answer in French?
Because of the time, I'll be faster in English. In terms of the laws that you put forward, both Germany and France, just to put out there, the Canadian Network on Corporate Accountability put out a model law in May 2021 that studied the kind of legislation that's advanced across Europe, consulting with other partners.
Sorry, with the limited time I have, who are you proposing that it apply to? The due diligence that you have suggested?
To Canadian companies and those importing into Canada, to those who are doing business
All
here.
Canadian companies?
The obligation to respect human rights, according to the UN guiding principles, the OECD guidelines that Canada has called on to, apply to companies of all sizes. What we have recommended is that obligation be placed squarely on all companies, and if there's going to be any exclusions for companies of smaller sizes, that be done via regulation in low-risk sectors, for example.
Thank you, Ms. Dwyer. Thank you, Ms. Bendayan. We now go to Mr. Bergeron.
Monsieur Bergeron. Thank you, Chair, and thank you to our witnesses once again for being here with us and for shedding light on this issue with your comments. My question is for Ms. Dwyer and Chipot. I imagine that you realize how counterintuitive your demand is. Nobody can be against apple pie virtues, but what you're asking goes against. But you're saying that we're not going for far enough in what we're doing. Do you not think that this is a good first step? Response. I'll follow up on what was just said to your colleague. There's this question of momentum, and the momentum can be lost if we put in place a bill that's not effective. Now is the time for Canada to have something that is effective and that works. Emily, perhaps you'd like to follow up.
Merci beaucoup pour
Thank you very much for the question. I think that the reality is that we recognize that our mission is to ask parliamentarians to put in place bills, legislation that make corporations responsible. So it's very difficult for us to show up here, to ask us to show up and support the bill that you're proposing. We want that the bill respond to the problem. We don't want a bill that will not respond or get rid of this abuse. And I think we've been really clear that there must be 3 elements for this law to be effective. It needs to force corporations to eliminate and prevent human rights violations. It has to help victims obtain remedies, and it should apply to all human rights. From what you're saying, I understand that instead of S211, you prefer S262, the bill S6262. What is it that would prevent S262 from being adopted if S211 is? The 2 bills could be complementary. It's not because one bill exists that another could not be put into effect. But what we've seen from the international experience is that once you adopt a bill against forced labor or modern slavery, the second step is never taken. That is, there's never a law on due diligence that requires corporations to uphold human rights and allow them to have recourse to remedies. So the government wouldn't help by only passing a law requiring reporting. The Labor Minister's mandate letter says that he should table a bill to eliminate forced labor from supply chains and ensure that Canadian corporations are not contributing to human rights violations. The two bills that we have before us, S211 and S262, are parliamentary initiatives. Are you expecting that the government, or that is members' initiatives, are you expecting that the government should also do something as a complement to these bills? Was the question for me? I'm answering the questions quite a bit, but as you've said, the Labor Minister in his mandate letter is clearly required, and I believe the parliamentary secretary is here. I think it would be useful if Canada, if the Labor Minister proposed a bill that's strong and effective. We haven't heard that a new bill will be tabled, or if an existing bill will be used for this purpose. But when it
for this slot. So we will now go to Ms. McPherson. You have 4 minutes, Ms. McPherson.
Thank you, Mr. Chair, and thank you very much for your testimony. You know, I am moved by the fact that we had earlier testimony talking about the urgent need for there to be this legislation put in place. We have seen other countries like Germany, like France, move on this. But I also recognize when the witnesses say that if we don't get this right, it could cause more harm than good. That in fact it is imperative that we get this right. And so because of that, I'm going to take a moment as well to give notice of a motion that pursuant to Standing Order 97.1, the committee requests an extension of 30 sitting days to consider Bill S211, an act to enact the Fighting Against Forced Labor and Child Labor in Supply Chains Act and to amend the customs tariff. And I'll tell you, I would like to have the minister join us here. I would like to hear from the government. I would like to give all parties, particularly parties who have not yet put any witnesses on the witness list, the opportunity to do that. But also, I would also like to hear the words that you'd said, Ms. Dwyer, about the need to listen to impacted communities. And I would like to take a moment to ask Ms. Actor if she would like to share the impact that this has had on her and her community.
If I may, with all, permission from the chair, with all due respect, what I understand, this is a bill for supply chain people. And you are the champion for bill. You know what to do with that. But what I can say that how workers living today and what they want, any kinds of bill that is taken by the country like Canada or Europe or US. So the workers, those are earning $78 a month, really wanted to know that what you are talking about, the forced labor, in your eyes, what is the forced labor is? I was in the factory, and before me, my mom went to the factory, and she had to leave the factory because she had 2 months infant at home. So she had to send me, rather she working, sent me and my brother, so 2 of us was the breadwinner for the 7 in the family. And all the reason was us to go to the factory because my mom did not pay the living wage. And that is I don't see anywhere. Child labor will be not eliminated. The forced labor will be not eliminated from the supply chain, any supply chain, if the parents are not getting living wage, if the parents are not having freedom of association at their production floor or in their factories where they are working, if their other labor aspects that they're supposed to be respected are not respected. It is so difficult for women to live with that little money they're getting today, let alone if she has 2 children in the family. She's tolling her life every day in these factories and thinking that there will be some changes in the production, in the sourcing country, that in their legislation will make some difference for our lives. But it's very minimum what I can see from the every, discussion that you are having. Yes, we are looking to the European Union due diligence law. The directive they just, proposed, it includes living wage, it includes freedom of association, it includes health and safety, it includes elimination of forced labor, it includes human rights. But I think you were talking about one of the elements of it. And I mean, my feeling that Canada can do a way better. Just giving an example, many of you know Bangladesh, maybe for Rana Plaza. So Rana Plaza, a factory which has collapsed with 5,000 workers, and that was 9 years ago. And a binding agreement has made a huge difference in back home. Now, over 2.2 million workers are working in a safe factories because we had Bangladesh Fire and echoed on Bangladesh Fire and Building Safety. And the beauty of it is because it was binding agreement. So every law, if you cannot bring this corporation under accountability, under any mandatory act, then there will be no difference make in the down to the supply chain. Thank you.
Thank you, Ms. Akhter. We now go to the second round. We only have 4 members who can ask a question. And for this round, it is 2 minutes, with the exception, of course, of Mr. Bergeron and Ms. McPherson. But the first slot goes to Mr. Chong. You have 2 minutes, sir.
Thank you, Mr. Chair. In fact, I'm not going to ask a question because I simply don't have enough time. I'm just going to make a comment for the benefit of the committee. Parliament can pass and adopt all the legislation it wants on forced labor, on child labor, but if the government doesn't enforce that legislation, if it doesn't operationalize the legislation, it's all for naught. And I'd like to use Xinjiang as an example of what I'm talking about. Clearly, a genocide is taking place in Xinjiang. Parliament recognized that. The UN Commissioner for Human Rights said that the birth rate plummeted between 2017 and 2019 by 50%, from 16 births per 1,000 people to 8 births per 1,000 people. Canada and the United States, subsequent to the USMCA, adopted legislation to ban imports using forced labor. Parliament amended the Customs Tariff Act on July 1st, 2020, to come into conformity with the USMCA, and a year later, the United States changed its laws in June of 2021. But in the 2 years since these laws have come into force, the United States has stopped thousands of shipments from Xinjiang from coming into the United States, but not Canada. In fact, there was a single shipment that was stopped at the border, but later released, of products, cotton products, that had come in from the People's Republic of China. And so I say all of this simply to say that if there is no enforcement of the laws Parliament passes, all of this is for naught. And I think the government needs to back up legislation Parliament adopts with real action to enforce the laws of this country. Thank you, Mr. Chair.
Thank you very much, Mr. Chong. We now go to Mr. Zuberi. You have less than 2 minutes, sir.
I'll give the introduction of my time to Mr. Sheehan.
Well, thank you very much, and I just wanted to inform the committee and the witnesses that the minister wanted to be here. Minister O'Regan wanted to be here today, but he had already been scheduled to some in-person consultation with employers about the replacement workers and the anti-scab legislation. But he is available on Monday for the committee. So thank you very much for your information.
In the remaining time, I'd like to ask Ms. Akhter, in terms of what happened several years ago in a garment factory in Bangladesh, there was international attention and focus put on this. Do you do you feel that that when we debate, discuss over here, when we pass legislation over here, that it does have a positive impact in places like Bangladesh and others, other countries where forced labor is happening?
If it is have a mandatory accountability and, keep holders, companies accountable, yes, it does. But, without any teeth, if you have legislation, that doesn't help at all.
Thank you. And I agree with you that we have to have teeth behind things. I'm also of the opinion that any attention and focus on these issues help the situation. We know this. I'd like to echo also what our colleague here at the committee, Michael Chong, said concerning the importance of implementing the rules on the books with respect to forced labor. Thankfully, we've had a robust conversation around forced labor in Xinjiang Uyghur Autonomous Region and other parts of the world. And we need to, as a Canadian family, act to halt these things from happening so that those across the world are not negatively impacted. I'll give the rest of the time to the committee.
5 seconds, but thank you for the 5 seconds, Mr. Zaberi. We're very grateful.
Sorry, Chair, just a point of order. Based on the offer from Mr. Sheen, is there a unanimous agreement for the committee to have the minister on Monday? Because I suspect there would be, but we should clearly delineate that. So, yes? Agreed? Madam Clerk, is that satisfactory? Does indicate it's been agreed? Okay, great. Thank you.
Thank you. We now go to Mr. Bergeron. You have 1 minute, sir.
Thank you, Chair. Very quickly, a rumor is going around that the government will table amendments to S211. Colleagues have had a chance to look at these amendments, not the opposition parties, however. One of the amendments would be that the bill, if ever one of the amendments were that the bill would be strengthened, do you believe we should be open to this possibility? Or do you think that this bill should just be discarded so that we end up with something that's more coherent and consistent overall and can meet the goals? Indeed, some elements could be added to this bill. However, it is the spirit of the bill itself that's a problem. A bill that's based on reporting is a problem. Every time you see this requirement to document, the only thing that happens is that a certain sector of the economy that provides documents or communications for large companies benefits. So at the very at its basic form, the bill is a problem. It's this problem with reporting rather. We really need a due diligence framework. That's the point we've reached.
Thank you. We now go to the last.
Thank you.
Ms. McPherson, you have 1 minute.
1 minute. I guess what I will do is direct this last minute to you, Ms. Dwyer. We know that Bill C-262 that's been brought forward by MP Julian is strong legislation. It's available. We'd be happy to have the Liberals adopt that. What else? What do you see in that bill that you don't see in this bill? You have a very short time, but just what's the last word you'd like to share with us?
I would repeat again, for us, effective legislation is legislation that actually requires companies to take action and not only to report, that helps people to access Canadian courts, and that applies to all human rights. And that's represented in Bill C-262 and is not represented in S-211.
Thank you very much.
Thank you. So on that note, allow me to thank all 4 of our witnesses. Your testimony was invaluable, and we're very, very grateful. Thank you, Ms. Dwyer. Thank you, Ms. Actor. Thank you, Ms. Chapot. And thank you, Ms. Hotchkiss, as well. But before, you can leave as you wish. But before doing that, before adjourning, if I may, There's several things I wanted to bring to your attention. There were 3 budgets that have been submitted by STIR, Subcommittee on Human Rights. Is it the will of the committee to adopt the 3? Yes. Thank you. So that
Mr.
was the
Chair,
first thing.
I
Yes.
apologize for not reading any of those 3 budgets. Do any of them include our travel?
Nope, none of them do. It has to do with STR.
Could I ask for an update of our travel?
Yes, the clerk. will respond
Thank you,
to
Mr. Chair. Yes, the detailed budget is being prepared regarding your travel. It has to be submitted to this BLE by December 2nd, and it will be presented to you on Wednesday of this week.
Thank you. Yes,
Mr. Chair, on that
Chair.
item, can we deal with the budget concerning the travel of this committee at the beginning of Wednesday's meeting?
Is that possible? Yeah.
The clause by clause is.
I think we can.
But I asked,
Chair
Mr. Chair, just
to
set
decide.
aside the first 5 minutes for the consideration of the budget concerning the travel of this committee.
Oh, sure. That sounds reasonable.
Thank you,
Everyone in
Mr. Chair.
agreement? Yep, we'll do that.
Yes, that's in camera, and then we come back.
Mr. Chair, I think we could leave you the discretion to figure out when we can discuss this. I think all committee members are interested in having the discussion.
Absolutely. Understood. So that's the first thing. The second thing, is it the will of the committee that the clerk make the necessary hospitality arrangements for an informal joint meeting with the Standing Committee on National Defense in a few minutes with the President of Estonia? Unanimous consent. Excellent. And finally, the committee will meet on Wednesday, November 23rd, and the notice has already been published. Yes.
Just on Monday with the minister coming, is that going to be an hour with the minister, and then how's that committee going to function?
Let's just make sure. I mean, that is what the PS said, but let's just. But it would
Mr.
be
Chair,
for
we
an
also
hour.
have an hour of clause by clause on Monday. So
On Monday we do?
on Wednesday,
Sure.
sorry.
It's Wednesday,
okay.
but he's talking about.
Next Monday.
And I don't want to say anything that I could be wrong on, but I think we'll be
You can let us
shooting
know
for.
by Wednesday?
If he's available for 2 hours, that'd be great.
No, I think it's going to be an hour. Thank you. Okay, so the meeting stands adjourned, but please don't forget, within a few minutes, the President of Estonia will be joining us, and it's jointly being done with the members of the Defense Committee. Thanks.